before I get into some other questions, I want to express my concerns over the Antitrust Division's proposed recommendations regarding consent decrees on performing rights organizations, specifically ASCAP BMI. Rather than meaningfully discussing and reviewing the consent decrees, the Antitrust Division appears to have committed instead to reinterpreting existing agreements in a way that fundamentally changes the way license rights are jointly owned music is performed. You've heard this already. The concern can be broken down in a couple of ways. Number one, this goes completely as contradictory to the U.S. Register of Copyrights, completely contradictory to the information that has been given from there. And the Antitrust Division's proposal to reinterpret the existing consent decrees to govern the PROs recommends a shift to 100% licensing and away from the current form of fractional licensing. The Reviewer of Copyrights has previously said it violates basically the principles of copyright law and interferes with creative collaborations among songwriters, negates private contracts, and impermissibly expands the reach of consent decrees. The way I see it, American songwriters are grasping for air, and the Antitrust Division just took them off life support. And there's issues here because in this instance, the acting head of the division of the Department of Justice is making a decision that flies in the face not only of another agency, but also, and putting an industry at risk. There is at least the appearance of conflict of interest among this head with the person making the decision at DOJ based on our previous experience. Now, listening to you all day, I'm not expecting a direct answer, unfortunately. But, and your answer earlier doesn't ring true. You've answered several times that they're continuing to look at this and be a part. Well, let me just add, I've had conversations with parties that have been a part of this, and they have been specifically told that the division has concluded that it would not be in the public interest to modify these decrees into fractional license. That sounds like it's already been made up. So we're going ahead and just preempting the time, and I would just ask, would you be willing to look at this, considering the concerns here, and do an internal independent review of this antitrust decision's recommendations?
Well, thank you, Congressman. Again, as I've said before, my understanding, as has been briefed to me, is that the Antitrust Division's review and recommendations, the review is not complete and the recommendations have not been made. That while they are consulting with various stakeholders, and I do not know if those are some of the individuals with whom you've spoken, that those discussions, I should say, are still ongoing. That it will be still a few more months until... I
appreciate that. I'm going to reclaim my time here because this is an issue that I know may not be on your radar at this point. I'm wanting to put it square front and center on your radar because this is a decision that affects a great deal. But it goes back to something that's very disturbing. I never thought I'd say this. I actually, and I say this with due respect, Attorney General, I miss Eric Holder. Because at least when he came here, he gave us answers. We didn't like it. But I've spent the last 4 hours listening to basically the Attorney General of the United States not willing to make a concrete statement of law. To not be willing to say that when given the opportunity by a colleague of mine, who made the decision in this case? I understand Director Comey stepped up and said, here's the decision we recommend. And y'all, you have been willing to say, as well, we just accepted the team recommendation. When given the opportunity to say, do you accept this decision? You've never answered directly that you own this decision. Do you own this decision?
Congressman, as I've stated, I made the decision, and I do accept. I did accept it, and therefore I made the decision to accept that recommendation. That was the action that I took.
The problem that we're having here, though, is you took a decision because you had to. Your own words just a few moments ago, that the meeting on the tarmac led you to do something. That was your exact words. It led me to do something, and that was basically recuse yourself, but didn't recuse yourself. You just said, I'm going to accept what they tell me.
It led me to discuss a decision I'd already made about how the matter would be.
Had you already had conversations with the team before you made this statement and before the meeting on the tarmac?
No. Before I had a conversation with former President Clinton, I had not spoken with the team. I had concluded in my mind how it should best be resolved because I had tremendous faith in their work and their integrity.
Did you have it best be resolved as far as what they're doing and the way it was going about, or the end outcome?
I had no conversations about the end outcome of the investigation.
Do you believe that there is such a thing as a strict liability offense?
Depending upon the statute, the environmental matters,
no, we went to law school. Is there strict liability offenses or not?
In OSHA, for example, there are. In some environmental cases, there are.
Simply yes or no.
I've given you two examples.
No, I want a yes or a no. Is there strict liability offense?
I've given you 2 examples.
I'm not. This is, again, the issue that we have here is there's no ownership at DOJ. It's no wonder the optics of this are so bad. I've never agreed probably with David Axelrod in my life, but the optics of this are terrible, and you today have made it worse. And as also a member of the military who just got through with my drill duty this weekend, you have basically, to me, offended every military member here who handles classified information, who does so with their training, and you basically said, well, it depends on this. I got a question for you. Riding down the road, the speed limit says 55. I'm doing 65. Have I broke the law?
You'd have to ask the Highway Patrol.
Oh,
they would likely write you a ticket. They would likely write you a ticket for that.
I'm not sure. I went to a small little small law school. We taught the law. Harvard, I'm not sure anymore. Did you break the law or not? 65 and a 55. My dad was a state trooper. Be careful with your answer. You're under oath.
As I said before, you would get a ticket for that.
Okay, so you broke the law.
You would be cited for that. That would be considered an offense.
In this, just the amazingness of this, when you've been asked many times, you said, I'm not going to talk about this. The day after, you said, well, I'm just going to have to accept whatever they tell me, because you're not going to do any investigation. You're not going to put the Attorney General, the top law enforcement officer's stamp of approval on it. You said, I'm just going to accept whatever they give me. Did you at least read anything before you had a press conference the next day? Did you at least look at the testimony from Hillary Clinton? Did you at least look at anything?
Time of the gentleman.
I did not hold a press
conference. Time of the gentleman has expired. The witness
statement.
can answer the question.
Thank you, Mr. Chairman. I did not issue a press conference. I issued a statement. I did receive a briefing from the team. It was thorough. It discussed the findings that they had come to. It discussed the legal analysis that they had made. My decision was to accept those findings. And as I've said before, that was my decision.
As a famous leader once said, the buck stops with me. Please go read that. This has been the president. Chairman. Director Comey, I appreciate you being here. You are, I believe, forthright, much more so than you said is in any criminal case we've had. But I'm also still in the military. I'm still in the Air Force Reserve. I went to my drill back in July. I was hit by an amazing amount of questions from different service members on this issue of how does the former Secretary of State get to do this, and yet we have members of the military who are prosecuted all the time. Your statements earlier were fairly startling when you said, I don't know if anybody else has been classified this. Just since 2009, the Department of Justice prosecuted at least 7 people in the Espionage Act, all for very similar cases. Now, you said go look at the facts. Well, we're looking at the facts in these cases. The interesting one, and you said that in looking back at your investigation, mishandling or removal of classified information, we cannot find a case that would support bringing criminal charges on these facts. All right. Well, it didn't take nothing but a simple legal search to find a Marine that fallen. Now, I guess their name is not Jane or Joe, so they did get prosecuted. Okay, and this is the issue under 18 U.S.C. 793F, gross negligence. This is what the Marine did. They took classified information that was put into a gym bag, cleaned out, washed, and took. All right, simple mishandling. Court of Appeals actually upheld this case, and this is what they said. That the purpose of federal espionage statutes is to protect classified documents from unauthorized procedures, such as removal from proper place of custody, which would mean how you deal with this, regardless of means of removal. It was apparent gross negligence and was approximate cause of the document's removal. It is, and they quoted United States v. McGinnis, said it is clear the Congress's intent to create a hierarchy of offenses against national security ranging from classic spying to merely losing classified materials through gross negligence or the mishandling of. It was sort of also ironic for me that when I had to go back in July in this past month when I went back, I had to do my annual information assurance training that went through everything that we have to do of handling classified information. I had been in a war zone, I've been in private. This is just common knowledge among most everybody in the world, obviously not to the Secretary. How can you then explain to me this Marine's mistake in taking classified documents or mishandling them is more severe than the Secretary of State who sent and received classified emails on a regular basis, including those that were originally classified, not those that were classified later, but were originally classified?
First of all, I'm familiar with the case, and I'm quite certain it's not a 793F case. It was prosecuted
as conviction was under 793F.
Yeah, I don't think. I mean, I'll go back and check again. I'd urge you to too. I'm pretty sure it's not under the gross negligence prong of 793F, but it's a Uniform Court of Military Justice prosecution, not by the Department of Justice. Am I remembering correctly?
This was from and is appealed out in the U.S. the Court of Appeals for the Armed Forces did actually hold it.
Okay. But regardless, I think even I don't think this is under the same provision, but even there, that's a case involving someone who actually stole classified information, hard copies. What people need to remember, and I don't say this to make a little of it. I think it's a very serious matter. What happened here is the Secretary used an unclassified email system, her personal system, to conduct her business.
And let's just stop right there. That in and of itself, and I understand it's coming. We've been through, you've been through a lot of questions. I apologize. But let's just come back to the basics here. We're trying to parse that I didn't have such a Sandy Berger or all these others who've been prosecuted. They took a hard copy. In today's society, and even understanding, if you go through any information assurance class, anything else, they tell you it cannot be on a personal laptop. In fact, there was another chief petty officer who had classified information on a personal computer. It went back and forth the world. That is not physical documents. It's on a, to parse words like that is why the American people are fed up. They're fed up with the IRS commissioner when he does it. They're fed up here. I'm not attacking your, I think you're one of the more upright people I've met. I think you just blew it. I think the Attorney General blew it. I shared this with her. And I think when we come to this thing, there's no other way that you can say that there's no others that resemble this. As a lawyer, you're taught all the time to take facts and put them, they may not be exact, but they fit under the law. You can't, I mean, so I guess maybe I'm going to change the question because we're going to go down to a dead end. You're going to say it wasn't. But let me ask you this. I want to change questions. Do you honestly believe that a lady, a woman of vast intelligence, who is the First Lady of the United States, who is a senator who had access to classified information, all the members here do, who is Secretary of State who had even further classification ability, even beyond what we have here. Do you believe that in this case, honestly, she was not grossly negligent or criminal in her acts?
First of all, I don't believe anyone other than my wife. My question is, what evidence do I have to establish that state of mind? And I don't believe I have evidence to establish it beyond a reasonable doubt.
Then really what we're saying here is this. And this is in essence what you're saying. You said, I can't prove it, and I understand. There's a lot of folks out there in the law that, they come to us all the time. I'm an attorney as well, and they come to and say, it's not what we know, it's not what we think, it's what we can prove. I get it. But here's the problem with this, and this is the person who's asking to lead this country. If she can hide behind this and gleefully get approval from the FBI through an investigation, which has been covered here thoroughly, then I just do not understand. She is either the most arrogant, which probably so, or the most insanely naive person we've ever met.
And that's bullshit.
Because when I actually show evidence of basically the same thing, which you can take facts and correlate to law. This is why the armed forces right now have the new term called the Clinton defense. I didn't know. I didn't mean to. It's on my. It's the Clinton defense.
Correct.
With questions like this, Director, we have give the ability now to where nobody takes this seriously. And this is why people are upset. When it was originally classified, she can tell all the stories she wants. She can have the backup from you that no prosecutor, which is again amazing to me, that a law enforcement would tell the prosecutor, because how many times I've been on both sides of this, where the law enforcement agent said, I'm not sure we have a case here, but when the prosecutor looks at it, the prosecutor says, yeah, there's a case here. I don't really, frankly, no offense, care what, if I'm prosecuting, what the law enforcement officer, if I can see the case and I can make it, that's my job, not yours. And yet now we have a whole system that has been turned upside down. Absolutely. Not because I don't believe your honesty of your people, but I believe you blew it because you, frankly, didn't have the whole situation into effect where the FBI would look political. And unfortunately, that's all you've become in this. And it's a sad thing because y'all do great work. You have to do great work. And you
Where'd you see the great work? I haven't
but I
seen
think it's
any
time
great
to start.
work.
We just bring down the curtain. There's a wizard behind the thing, this Hillary Clinton, who is playing all of us because she's not that naive. She's not stupid.
Absolutely.
She knew what she was doing because she was simply too board.
No,
if she, God forbid,
she
gets in 1600 Pennsylvania Avenue and just gets bored
that,
with the process, then God help us all. Mr. Chairman, I yield.
Mr. Chairman, there's only two. The director is permitted to respond.
Yeah.
Two pieces of that I need to respond to. First, you said hiding behind something. This case was investigated by a group of professionals.
Really?
So if I blew it, they blew it too. Career FBI agents, the very best we have were put on this case, and career analysts. We are a team. No one hid behind anything. American citizens should insist that we bring criminal charges if we're able to investigate and produce evidence beyond reasonable doubt to charge somebody. That should be true whether you're investigating me or you or Joe Smith on the street. That's the way this case was done. It's about evidence. And the rest.
Like there wasn't any evidence? you know, I get very upset with this. There wasn't any evidence. Excuse me? Excuse me? Had somebody else did 1/8 of what she did, they'd all be arrested, believe me.
Mr. I'll let go.
Mr. Chairman, I would, and I apologize.
He's compromised.
I'm not, this is the problem though. When you take it as a whole, it's been said up here, this is a unique case. You've talked about it being a unique case. Director, this is a unique case because I truly, and I don't think you convinced hardly anybody except your own group, I don't think you ever said they couldn't blow it. They blew it. Anybody else would have been prosecuted under this.
Absolutely.
In my humble opinion,
You're just wrong.
you say no.
Wrong. We'll just have to agree to disagree.
Well, unfortunately,
Really?
there's a lot to disagree
I'd have
on.
to,
Thank you, Mr. Chairman.
really,
On
lock
September
them up,
28th,
lock them up
2015,
and
the
stop
VA
wasting the
Office of Inspector
taxpayers'
General recommended
money.
the U.S. Attorney's Office, District of Columbia, pursue criminal charges against 2 VA executives it found to have abused their position in order to take jobs with less responsibility while keeping higher salaries. The report detailed how the VA executives pressured subordinates to accept positions transfers only to volunteer for the vacated jobs while keeping their original salaries and having the VA pay them for more than $400,000 in taxpayer-funded relocation benefits. Will the DOJ pursue charges against these employees, and if not, why not?
Thank you for the question, Mr. Chairman. With respect to a matter that's been
Lock
recently
that
referred to
witch
the
up,
department,
too.
it's a matter
The
that's
Muslim Brotherhood,
currently under review, and so I'm not able to comment on it at this time.
Really?
Well, I think the one of the things issues, and I think the gentlelady from California also talked about this as well, the VA issue is something that's been ongoing. And I think you made a rightful statement that our veterans deserve that support and help. And I think we're seeing we've seen it in Georgia where people are just transferred, not held accountable. And there's some that have been held accountable. I think coming to this conclusion, it's more than just words. Actions have to be taken here, and to simply say we're going to look into this is frankly the American people on both sides of the aisle are not satisfied with that kind of a response. I do appreciate your mention of Veterans Court. Veterans Courts are working in my home county in Georgia, and we're expanding that process. Governor Dill, as well as local DAs and judicial circuits, have worked well in that regard. So I would commend that and continue the process as we look forward. I want to move to an area that is coming up a little bit. It's on trade secrets issues, and we recognize that trade secrets are an essential form of intellectual property, and companies in America, however, increasingly target sophisticated efforts to steal proprietary information, harming our global competitiveness. There are many in Congress, including myself, who believe we need to create a federal civil remedy for the misappropriation of trade secrets, keeping and harmonizing the legal frameworks so that companies can protect. The administration, through IPEC recommendations, supported a call for private right on action on trade secrets. Do you join them in recognizing that such a private right of action would be beneficial?
Certainly, Congressman, you raised an important issue and one of great priority to both me and the entire Department of Justice. We are committed to prosecuting cyber criminals who do seek to steal our intellectual property. I believe the last recent estimate was that we are losing possibly up to $250 billion worth of intellectual property a year through hacks and crimes and the likes. And we look forward to working with you on the proposed legislation that you mentioned, that you discussed.
So you do believe a civil private right of action would complement your efforts, given the resources and limited actions many times that you have? That would be something that would complement your actions that you currently have?
I'd like to see the language, but certainly we look forward to working with you on that.
Okay. Also, I want to, and we're jumping to several different issues, and one I want to come back to that was brought up earlier, and it has to do with sanctuary cities. And it goes back to a question that I want to know: has DOJ taken any action to withhold law enforcement grants or other funding to sanctuary jurisdictions? If not, why not?
Well, the grant process that under which DOJ operates is a formula-based grant-making process, and different organizations and entities within cities apply. Certainly with respect to our grant-making process in general, we're always cognizant of concerns that come up within certain jurisdictions. We have found that through our grant-making process, we can effectuate great change in a host of very significant and
But Madam
focused
Attorney General, if I don't mind interrupting here, but shouldn't following the law be a prerequisite for a grant?
Certainly we work to enforce not only the laws that you are referring to, but all the laws with the cities with whom we work.
But getting a grant, if you're not following the law, have no intention of following the law, why should, I mean, at that point in time, the application should be just set aside, follow the law, we'll talk to you about your grant. Why can't we get to that?
Well, thank you for the question, Congressman. Certainly it's been raised in a number of contexts. We do find that our grants are very focused on specific areas. For example, providing more police officers on the ground.
Again, you got great talking points. I appreciate that. That's not my question. How can you get, if you're using money to circumvent the law, as you just basically implied, that's even worse. You don't incentivize this kind of behavior. Why would it just not be a permanent stop to the grant-making process until a city or a municipality or a government entity complied with the law?
Well, Congressman, with respect to our grant-making process, we do make very discrete, focused grants to specific portions of city government.
So in essence, you have subsidized lawless behavior, because that's what the Attorney General of the United States of America has just testified to. And you can sit and, I mean, that's what you just testified to. You'll give money to a locality that is not following the law because you want to use your grant in discrete private ways. Is that what you just said?
We use our grants to incentivize better behavior in a host of ways, and our grant-making policy is focused on a very rigorous application.
So you're telling the people of the 9th District of Georgia that taxpayer dollars that come to them is being used and will not even be considered if a locality is not complying with the law, you will still give their tax dollars to a locality that's not complying with the law. Is that your testimony?
We look at a host of factors.
So the answer is yes. Not your host of factors, it is yes. I mean, this is the part that...
Exactly.
The ranking member made a great point earlier when he first started. I'm going to finish up with this. I've had these hearings, and you'll be back before us at another time, and I look forward to those hearings. But what is amazing to me and the American people watching here is, he said, tell the truth and work those, but also being prepared for questions. You're going to get VA questions here. You're going to get sanctuary city questions here. You're going to get a lot of host of questions, and even the ranking member listed those off. Coming and giving an answer that we're looking for, that we're not being, basically a setup where the people don't understand that, is the thing that very much frustrates most people with Washington, D.C. You've been very well prepared for this by those who want to prepare you for these hearings. There's just a big disconnect at a certain point in time when the Attorney General of the United States will not say that they would not want to give money to an organization or to a locality that is not following the law. We're still going to give taxpayer money. That is unacceptable, and what most people find.
Absolutely. 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 Let us know what you think in the comments below, and thank you so much for watching.